If we move to later equity, we have this continuing distinction between common law and equity. But during the 18th and 19th century, this became really rigid, so that people would have to go either to the common law court or to the equity court. And they would find that they had, which was of course extremely expensive. You had to go to 2 courts sometimes, and that was a disaster. So in 1870, the United Kingdom passed its Judicature Act. Now what this did was it said that instead of common law and equity having to be decided in different courts, they could be decided in the same court. So the court could listen to common law argument and listen to equity argument, and it could then make decisions that involved both common law and equity. Now, the Judicature Act was followed by most of the Australian states fairly fast, within 10 or 20 years. New South Wales was the outlier. New South Wales had what we call its great leap forward to the 19th century in 1970, when it passed its own versions of the Judicature Act. So it took a very long time in New South Wales for equity and common law to be determined in the same courts. And because of this late Judicature Act process in New South Wales, and because the dominant equity lawyers in Australia for a long time were people who had been at the bar or the bench in New South Wales and Australia became the leading proponents of a view of equity that said that equity had to remain distinct from common law, that even though it was decided within the same courts, it was very important that what they said was that the streams of common law and equity should not mingle. After the Judicature Acts, there was a lot of argument about how much mingling there should be between the streams of equity and common law. And for a very long time it was thought that they should not mingle, and they should not do what we think of as fuse. So we now have a range of jurisdictions around the world which vary from thinking that common law and equity are just more or less can be heard together, thought of together, and actually shouldn't be seen as distinct areas of law, which is the position in the United States, and the position in Australia, which is still more or less that common law and equity should be seen as distinct, and fusing them is actually a fallacy. What this is really about is, to what extent can we change the law of equity? So can we change the law of equity by analogy with the common law? Can we change the law of equity by bringing things in from the common law that weren't there before? Can we do those sorts of things? And to what extent should we see these areas as really distinct areas? So the answer in Australia at the moment, but we don't know for how long, is that we have to see them as distinct areas of law with distinct ways of thinking. And so when we talk about common law and equity in Australia, we're doing something that's more like, in many ways, more like the 19th century in the United Kingdom than it is like the 21st century in the United Kingdom. So this means what we're talking about when we talk about modern law and equity is that we look at equity and we look at things that equity does that are distinct. So in our legal system, equity, for example, has the vehicle of the trust, and the trust is a very important part of equity. Equity also has a range of doctrines which are designed to control things like people's departures from fairness and equity and so on. The rules are quite rigid. We are not talking about a really easy movement of rules or changing of rules. Equity is not the flexible remedial process that it was in the Middle Ages. Equity is now a distinct body of law which has its own rules. Some of those rules can be used to modify parts of the common law. That's the basic position in Australia now.